is on okay. All right. People sit in the waiting room. Letting them in now. Okay, attendance is running. All right. Any questions before you get started? Any questions before we get started? All right. I've now finished the midterm review session. Oh, Macy, go ahead.
Sorry, one question. On the last assignment on the syllabus, it says makeup
I'll get to that.
be determined.
I'll get to that.
Okay.
Yep, I'll get to that in a minute. Yep, thank you. Thank you for reminding me. Yesterday I finished going over all of the midterm sessions. I would say about 75% of you came, which is good. I appreciate those who came. I was basically my entire month of weekends. I was doing it basically from 12 till 5 or 6 every Saturday, Sunday this weekend. So it was a lot of work, but I enjoyed it. But a quarter of you didn't. Some of you emailed me with excuses and said you couldn't come, so I was able to reschedule. But a lot of you just never showed up and never got your midterm grade. I don't know what to make of that, to be perfectly frank. It required, a modicum of effort on your part to just email me and say you couldn't make it. I'd be happy to rearrange it, but a lot of you just never did. And that's disappointing. You're going to have a final in a couple weeks, and you have no idea where you are in the class. And I don't know, how you can go about preparing if you have no idea where you are. It's disappointing. And it's not just your class, the same in my other class as well, but a quarter of the class just never showed up. Which is fine. It's not my, it's not my problem. It's no sweat off my back. If you can't take advantage of an opportunity, then that's on you, not on me. For those who came, though, I think it was very helpful. I apologize. It took almost a month to get through everyone, but it was a lot of people, and I probably put too much time into this, more than I should have, but I found it worthwhile. For people who came who tend to get less than a B, I gave them the chance to rewrite it. And that was very useful because it gave them sort of a reality check, a wake-up call saying, this is not good. I need to fix this. This is not working. And I gave them, I hope I gave everyone some useful tips. And many of you came back and rewrote your exam. And I was able to review and say, this is much better. This is a B plus, or maybe even A minus or an A, right? Or a B or a C, whatever it happened to be. But I would always give the revised score. I'm grateful for that. And I mean that sincerely. That shows that you really are committed to improving yourself. And you're not just sort of going through the motions. Especially in this semester where nothing makes sense and you're all just figments of my Zoom imagination, never seen any of you in real life. You may not even exist. You're all deep fakes for all I know, right? But it means a lot to me when you actually take the time to revise something and come back a second time to make things better. Okay. So I appreciate that. A lot of you have asked me if you can submit, different exams that you've taken. The answer is yes, but I'm going to put a cutoff because we are coming close to the end of the semester. I'll make the cutoff the last day of class, the 23rd. If you want to send me an old midterm or an old final you've taken, and you send it to me the 23rd, I will be happy to go over with you. I may not get time on the 23rd to do it. It might be the next day, but if you send it to me the 23rd, I promise I'll review it, and I'll be happy to score it for you. I can't let this drag on forever because the semester runs quickly. So hopefully that's okay for everyone. It gives you ample time. I gave you a week's warning. So by Monday the 23rd, send it to me, that's fine. Okay. Macy very kindly reminded me that the end of our semester is not settled. So here's what I want to do. Let me just bring up the syllabus for you all so you can look at it. Let me do a screen share. Okay. All right. So here we are today. We are November 16th. We're right in schedule. we're going to do the sex discrimination cases today. On Wednesday, the 18th, we're going to do the abortion cases, or at least the first round of the abortion cases. Okay. The last scheduled day is the 23rd, and we'll do the modern abortion cases. All right. I need to do a makeup date. I think I had feels like a lifetime ago. There was a Jewish holiday. I think it's canceled class. I apologize. Not really, but I appreciate your flexibility. What I'd like to do for the makeup is to do it the next day, on Tuesday the 24th. Same time, same place on Zoom. 10:30. 10:30 a.m. on Zoom the next day. I realize it's a tight turnaround, but I don't want this to go after Thanksgiving, so it won't stick. There's a lot of continuity between the abortion cases and the gay rights cases. They're very closely linked, so I want to do them back to back. I won't be taking attendance at this class on the 24th, so if you can't come, that's your decision. I won't fault you. It's going to be on YouTube, so you can watch it later. But that's when I'd like to do the final makeup class. Again, I'd rather do it before Thanksgiving than after Thanksgiving, because once we get after Thanksgiving, you're in finals mode and your minds go to the wind. All right. Now, the harder question for me to give you is the final exam review session. Your exam is on the 12th. And I know at this point, you're all 2Ls, you have different schedules. Perhaps if a few of you could raise your hand and tell me what date you would find useful. I'm around, I'm not going anywhere. But if you look at your calendars now, just raise your hand. I'll call on you in order of the queue and tell me what dates you'd find useful, and I can work around that. I know you have tax. I know you have, God, you'll complain about tax nonstop. I know you have tax, right? I know you have evidence. I know you have responsibility. I know you have other classes. So anyone, just go give me a hand here. Yes, Project, go ahead.
Maybe the day before Thanksgiving.
Okay, people said that. So that would be Wednesday the 20... Let's look at my calendar. That'd be Wednesday the 25th?
Yes.
Okay, I can do that. I'm not traveling the 25th. I'll do a poll in about 30 seconds when I get some more dates. Okay, so one option is the 25th. What else? Macy, go ahead.
What about December 10th, just as like a final review?
Too soon. Yeah, no, that's too soon. I'm sorry. My cutoff is usually 48 hours before the exam. I can't do a review session 2 days before. I know why, because I know your tax file is the 9th, but it's too soon. I can't do it that late. But I appreciate that answer. So I'm going to make option A 11. What did I say? The 24th. What did I say? 25th. I'm sorry. So option A is the 25th of November. Okay, Samiha, go ahead.
I was going to say December 7th.
Pearl Harbor Day. Okay, well, is there anything around that or that conflicts with December 7th? I don't care. I'm not going anywhere. I don't leave my house anymore. But is there any obvious problem with December 7th?
There are some people that have a final for wills on the 8th.
Okay.
I don't know if that would interfere.
Okay. All right. Well, I'm going to just list options on the poll. Okay. So we have option number 1 is November 25th. Option number 2 is December 7th. What other options should I put in the poll? Again, it matters not to me, but I want to make sure it's meaningful for you. Yes, Vikesh, go ahead. Vikesh, go ahead. Yeah.
Oh, sorry. We're just going to throw out Sunday, November 29th.
November 29th.
Correct.
Okay, so that's a Sunday, November 29th. Okay. And I guess that's after Thanksgiving before you start exams, right?
Correct. And if that date's okay with you, I know it's a weekend.
Oh, I don't care. What do I have? Again, I don't leave my house. It's fine. All right. Okay, so we have the 25th, the 29th, and the 7th. All right, Catherine, do you have a proposal?
The following Sunday, December 6th, maybe.
December 6th? Okay, I can go with that. Makes no difference to me. Okay, what else? You have 4 options. You have up to 5 on the poll. Okay. Anyone else? Going once. Going twice. All right, so I have 4 options. I'll just put a poll out right now. The poll question. Just give me a second to get started. This is actually a very democratic way of doing it. I appreciate it. If there are any absentee ballots, too bad, you don't count. Sorry. That was mean. All right, drive-through ballots also don't count. All right, so here's the question. The 25th, the 29th, the 6th, the 7th. And I'll put it to you, and then that's what we'll do. It'll be by Zoom. It'll be recorded. If you can't make it, you can't make it. That's when we'll do it. Oh, wow, this is close. All right. I got 51 out of 57. Everyone vote. This is real. It's actually really close. $55. 2 more people. Please vote. All right. Get another 5 seconds. All right. December 6th it is. Real close. Okay, you voted. Can't complain. All right, so we'll do it. December 6th at, we'll just say noon. That makes sense, everyone? Okay. ConLaw, put in my calendar. Final exam review. Okay. And the setup for that, what I'll do is I'll have you on your own time do an old final exam, and I'll go over an old final exam. I find that's the most effective way of doing a review. If you have questions, you can bring them to me on the 6th. I usually make the cutoff for the exams 48 hours before, so you can email me stuff later if you want, but I would encourage you to bring questions to that exam. That way you have some time to think about it. I find that as you get closer to the exam itself, the questions get really bad. People start panicking, they freak out, like, oh my God, I don't know anything. And they just, I had students who actually, you don't know me, but I used to have business cards on my desk, which has my cell phone number on it, which I don't usually give out, but it's on my business card. And some students took my business card and I forgot about it. And they were actually texting me the morning of the exam with questions. And I'm like, no, you're not texting me. I know professors allow you to text that. That's not good. It's a bad idea, I think. So I'm like, if you want, I replied to their text in the email. It's like, you can email me if you have a question. I don't want people texting me. It's a bad idea. I think it presumes too much informality. If it's approved, fine, but just don't text professors. Email's good. We're responsive. So anyway, so 48 hours before questions, that'll be my cutoff. And your exams the evening of the 12th. I think the school sent you a message that there are now going to be spaces to take the exams in the building, which is good. A lot of you asked me about that, so you can take in the building. So I'm happy the school is able to accommodate that. I did ask, what happens if those rooms fill up? And the short answer is go to the library. They have the carols, so there should be enough room for everyone. The school assured me this room, so I will hope there is. My fear was that, everyone shows up to take the exam in the building and there's not enough space, and then people are freaking out. So I asked, they said that they got space. So, okay, we're good. All right, what else? Anything else in your minds? Okay, good. Glad that didn't take very long. Very good. Thank you for that. And by the way, we're right on schedule. I did not think we'd finish this semester, and we're actually exactly where I thought we'd be. So I'm very happy with that. We didn't need to do a lot of extra stuff. So good for you all for keeping up the pace. let's start a material for today. We're continuing our discussion of equal protection, right? And in our last class, we discussed through these three tiers of review. I presented it as if it was a sort of this coherent doctrine, but it sort of evolved over time. At the very beginning, right, in the 1940s and 50s, the court began to suggest that certain types of classifications are suspicious or suspect. And we saw in Caroline Prague's footnote 4 that when laws target racial minorities and discrete against minorities, that the courts have to be a little bit more engaged, that they should require more what they call exacting scrutiny. And then we saw in a case like Korematsu that when there's a racial classification, there must be a rigid scrutiny. Oh, I'm sorry, I forgot to put the closed captions on. My apologies. Thank you for the reminder. Give me 1 second. This, by the way, is why your other professors will never do this, because it actually requires work. That's not obvious. You have to do stuff and copy stuff, and it's not going to happen. I've tried to tell my colleagues about it, and they're just not interested. So you're stuck. I'm sorry. But we saw in cases like Korematsu that the court says rigid scrutiny is necessary when there's a racial classification. Still, the court upheld the classification in Korematsu because there was a really compelling interest behind it. And the court thought it was justified. But then we get to the 1950s. And then we have Brown. Brown didn't talk about strict scrutiny. Did you notice that? It didn't discuss footnote 4. It didn't discuss really anything that's doctrine. It was based on this sort of, limited discussion of social science and how education is very important, but it didn't fit into the framework that we now know. I think the clearest case that discusses what strict scrutiny is the Loving decision with the interracial marriage. I think that opinion, very clearly articulates what happens when you have a racial classification, and it walks it through it very directly. So you don't really get a clear articulation of the strict scrutiny doctrine to the 1960s with Loving. All right? And throughout this entire time, the 40s, 50s, and 60s, if a law didn't fit within this sort of narrow category of racial classifications or national classifications, they were non-suspect classifications. And the court would review non-suspect classifications with deference, deferentially. They would give the benefit of the doubt to the government. We call this deferential standard review rational basis review. Why is it called rational basis review? Because the court only asks if the government has some rational basis, some plausible reason why they're acting. They don't need to have a good reason or even a compelling reason. They need to have some reason. And they're allowed to be not so precise. They're allowed to make classifications and separate people. And the example I like to use is age, right? One state can make driver's license at 16 and one state can make driver's license at 18, and that's just fine, right? The states can chop people up based on their age, and there's really nothing suspicious about it, right? It's expected that minors will have certain disabilities, legal disabilities at least, I should say. And there's not anything suspicious, right? We don't think that, oh my God, the government's trying to punish kids. No, it's just kids aren't as mature, right? They don't have as much responsibility, so it makes sense to let them drive at 16 or 17 or 18. Okay. So this two-tier approach developed throughout the 40s, 50s, 60s, right? Where if you weren't racially classified, you were basically stuck in a rational basis world. But then we get to the issue of sex and gender. And for the longest time, sex discrimination was viewed as non-suspect. So we have cases going back to the 1800s. And this is a good time to review a little bit. One of the first cases we did after the 14th Amendment was Bradwell. Remember Myra Bradwell? She was a woman who wanted to be a lawyer. And the court said, no, the right to become a lawyer is not a privilege or immunity of citizenship. But then you have the concurrence by Justice Bradley, who goes on this very long rant about how women's place is in the kitchen, and this is her destiny. Her destiny is to be a subject of man, and she has no rights. Okay? And you have a very early articulation of how the court approached women. Fast forward to Muller against Oregon, 1908. I'll be off by a year or two. In this case, the state of Oregon imposed a limit on the number of hours women could work. Now, remember, Lochner held that the bakers could work as many hours as they want. But Muller upheld a limit on women's work hours. Muller wasn't based on any sort of constitutional doctrine. Instead, Muller was premised on social science. Future Justice Louis Brandeis put in the famous Brandeis brief, which said that women have these health conditions that make them inferior. They have less blood. They have more water in their blood. Their reproductive organs will fall out if they work too much. Sort of insane stuff that even at the time was considered insane. And the court said, "Oh yeah, that's right. Yeah, uterus fall out. Exactly right. Perfect." And the court upheld the sanction for women to work. All right. Then we go forward to Atkins v. Children's Hospital, 1926. Might be off by a year or so. And then we have Justice Sutherland, who was a conservative justice, but he was very much in favor of women's rights. He had introduced the 19th Amendment when he was a U.S. Senator. 19th Amendment guaranteed women's suffrage. Sorry, got to clarify that. And in Atkins, the court held that a minimum wage law that was only applicable to women was unconstitutional. And Justice Sutherland says, wait a minute, right? Women have just as much power to negotiate contracts as men do, right? The state cannot interfere with a woman's right to negotiate her wages, right? We've had women's suffrage, women have the right to vote. We have the increasing equality. And Justice Sutherland says that the legal barriers between men and women were declining almost to the point of non-existence. Again, that was 1926. It's almost 100 years ago. And the court declared unconstitutional the restriction on the minimum wage for women. Okay, let's fast forward about a decade, 11 years, to West Coast Hotel v. Parrish. In that case, Washington State enacted a law that imposed a minimum wage for women only. Men didn't have the wage, but the women had the wage. All right? Now you might ask, Josh, wait a minute, didn't the court say in Atkins that you couldn't do that? Well, yeah, Washington didn't care, right? They basically enacted a law that they knew was against Supreme Court precedent, basically daring the Supreme Court to, okay, let's see what you do about this, see if you can fix it. And West Coast Hotel was the famous opinion where Justice Owen Roberts cast a vote to uphold the progressive law. And that case signaled the end of the conservative movement of the court where they would review skeptically progressive laws. And West Coast Hotel said, well, women, it's nice and all equality, but the state has an interest in protecting you. And if the state decides that you can't negotiate your own wages, that's for the state to decide, not for the courts. So West Coast Hotel was either a step forward or a step backward for women, depending on how you count it, right? It might be a step forward in the fact they have this minimum wage and they would be able to be guaranteed these sorts of better working conditions. But it's also a step backwards in a regard because now they were viewed as these sort of inferior wards. Men can negotiate their hours, but women couldn't. Eventually, the court said all minimum wage laws were valid. So this sort of distinction between men and women faded. So it was not very long-lived. But at least West Coast Hotel, in Justice Sutherland's mind, was a step backwards for women equality. All right, so that was 37. Over the next 3 decades, my math is right. Yeah, over the next 3 decades, the courts didn't really have much to say about women. They sort of just took the back seat because the most predominant cases concerned racial equality with school segregation. That was like the sort of focus. But in the late 60s and early 70s, the court began turning again to women. And a lot of the credit for this shift belongs to the now late Justice Ruth Bader Ginsburg. First semester she's not here with us, so it's a have to note that she became the head of the ACLU's Women's Rights Project, where she would litigate women's rights cases. Before that, she had a very, very great story, which I'll just briefly thumbnail. She graduated, or she attended Harvard Law School with her husband, Marty. He became diagnosed with cancer, and they had to move to New York for his treatment. So she transferred from Harvard Law School to Columbia Law School. And I think she was the only person who made it to both the Harvard Law Review and Columbia Law Review. She graduated number 1 in her class at Columbia. Could not get a job as a lawyer. Could not get a job. Law firms would not hire a woman, especially a Jewish woman at that time. Not going to happen. And people gave her a job as a legal secretary if they wanted. So she was able to get a gig teaching at Rutgers Law School in New Jersey. And in that capacity, she began to develop expertise in constitutional law and really Civ Pro. Her expertise was Civ Pro. If you want to read a good Ginsburg opinion, read a Ginsburg Civ Pro opinion. I don't know if you have any in your books, but she was a stickler for civil procedure. My God, I would not want to have to argue a civil procedure point with her. I would lose. It's just she was. Even Scalia would say the best Ginsburg was Civ Pro. Just that was her thing. I think she went to Sweden to study Swedish civil procedure, and she taught herself Swedish. Who the hell does that? I don't know. Anyway, she was very remarkable, very remarkable. But her big claim to fame was running the Women's Rights Project for the ACLU. And in the 70s, the ACLU was trying to put together various projects that would challenge sex-based classifications. Okay? And the strategy was very deliberate. Rather than saying, oh, poor women, they're being disadvantaged, they looked for cases where it was actually the guy who's being disadvantaged. So when you think of the 2 cases we have today, right? Frontiero and Craig against Boren. In both cases, the plaintiffs were actually men, right? Right? The person being disadvantaged were actually men. In the first case, it was the husbands that were being denied certain benefits. And in the second case, it was boys being denied the power to buy beer. And the thinking was that if you bring in a case where it's the man who's being disadvantaged, perhaps the all-male Supreme Court would be more receptive to those claims, that they'd be more willing to accept them. And in hindsight, it worked too enough. Maybe the court would come out the other way no matter what. The votes were there, but this was a strategy. So you have both Frontiero and Craig. And Ginsburg argued Craig. And if you go watch the video, I have some of her arguments in the video. You're welcome to watch it later, or hopefully you already did it. All right. Any questions so far? All right, who's up next? Who is up next? Come on. Who is it?
Professor, this is Lauren Danielson. I think it might be me, but I'm not sure.
Lauren? Well, unless anyone else objects, I'll call on you.
Okay.
All right, Lauren, help me out here. What are the facts in our first case, Frontiero?
So Frontiero, okay. So this was a case the appellant was Sharon Frontiero. She was a lieutenant in the U.S. Air Force. And she had requested increased quarter allowances, I guess money for housing, and housing and medical benefits for her husband, on the basis that he was her dependent. So he was a full-time student. He was also a veteran, and he was a full-time student at a college nearby. And basically, the Air Force was not allowing her to have these benefits, like automatically. If it would have been a man that had been applying for the, I'm getting lost. Sorry.
That's okay. Take your time.
A man that had been applying for extra money for his wife's dependency, that would have happened automatically. But in the case where it was a woman officer, she was having to prove that her husband was dependent on her for more than half of his support.
Okay, very good. All right, let me try a poll question. I'll call poll question number 1. It's a short answer. Thank you, Lauren. Here's your question. Okay. Why? Oh, yeah, it's multiple choice. Sorry. Why did the Air Force impose additional restrictions on the husbands of female officers than on the wives of male officers? Why did the Air Force impose additional restrictions on the husbands of female officers than on the wives of male officers? Just think carefully about this answer.
Professor, you want us to answer it in the way that the case?
I'm answering the question.
Okay.
I asked the question. I want you to answer it. I see what you're getting at, Lauren. I know what you're doing, but just answer the question. Okay. Another 30 seconds or so. And I think Colin's up next. All right, Colin. How was that here? You here, Colin? Okay. Brigitte, you here? I saw you
Yes,
earlier.
sir.
Okay, Brigitte. What did you put here?
I put administrative convenience.
Okay, what does that mean?
It is more logical for the military to assume that women are dependent upon men as opposed to men being dependent upon women.
Why do you think it's more logical to make that assumption?
The long vested values of our society.
Okay. And so, Brigitte, just help me close the gap. If a husband comes along and requests these benefits, what's the presumption? What does the government presume in that case?
Of course, the woman is relying on him.
No, I'm sorry. If the female, there's a female officer, and there's a husband who claims he's dependent on the female.
Oh, that's fraud.
It's fraud. Does the government have an interest in limiting fraud?
Absolutely.
Okay. All right. Who's next? Emily, you next? You here, Emily? Emily?
I'm here.
Emily, what'd you put here?
I put the same thing. I put administrative convenience.
Administrative convenience. Okay. Now, Emily, let me ask you a follow-up question. If the government was really interested in making things more convenient, like eliminating fraud, what could they have done? What else could they have done?
To eliminate fraud, I think they could have had everyone prove that, like the men and the women prove that their significant other was dependent on them.
Would that have been difficult? Would that have been difficult to do?
Yes, that would make it harder, but it would make it less likely that there was fraud.
Connor, are you here?
Yes, ma'am.
Connor, is it possible that there might have been some women who were actually the breadwinners, so to speak, if I can use that outdated phrase, that women were actually the primary income earners in the family? Was that feasible?
Yes. I mean, especially in this case where he's a student, so I assume he's spending a lot of his time studying.
No, I'm sorry, but forget this case, but in general, is it possible for the women in the household to make more money than the husband?
Yeah.
Do the government suspect fraud in those cases?
I wouldn't think so.
No. All right. So, Catherine, let me ask you a question, right? Why was the Catherine here?
Yes, I'm here.
Okay, that's right. So, Catherine, let me ask this question, please. Why do you think it's the case that the government was very much worried about husbands committing fraud, but they seem to be much more trustworthy of the wives potentially committing fraud?
Well, I mean, again, they claimed that it was, for, I guess, efficiency, they didn't have to do as much paperwork, but I don't know, potentially sexism, but that was just the pretext.
Okay, you said a very important thing. You said pretext. Tell me what that means, please.
Basically, it's the stated reason for your means to meet your ends is not the real. It's not the real reason.
Oh, wow. You said a lot of good things. So just say that one more time. You said means and just repeat what you just said. It's very good.
Basically, so the means that they've instituted to meet their end goal is not their end goal is not really the real reason that they've implemented these means. It's potentially sexism, that women are inferior and belong at home.
Okay.
And are the breadwinners.
Okay, excellent, Catherine. Thank you very much. Let me try to summarize that for a bit. In ConLaw, we often talk about the means and the ends, and I've mentioned this before, right? So the question I put to you is, why did the government impose this restriction on the husbands but not the wives? And a lot of you said things like administrative convenience, to eliminate fraud. I'm looking at your answers here, right? Right, you said different things. Let's see if I can do a word cloud, see if this actually makes sense. Right? We agree that the government has an interest in reducing fraud. I think we all agree on that. And I think we all agree the government has an interest in, making their processes easy. This is a busy time. The government's fighting, wars overseas. They got a lot of stuff going on. Right? They can take shortcuts. And here they took a shortcut. And they said, in order to reduce the risk of fraud, we're going to take the shortcut and simply assume that wives are not the primary earners. And we're going to assume that husbands are the primary earners. So if a husband requests benefits as a dependent, we'll make them fill out some more paperwork and prove their actual dependencies. But we won't make the same requirement for wives. Why? Because at this time there were very few female officers, right? I don't know the number, but I'm sure it was a very small number. And there were probably even fewer husbands of female service officers, right? It's a small number. But there were a lot of wives. There were a lot of wives of male officers. And if you had to review the application of every single male officer, it would take too much time and effort. Right? It would take too much time and effort. So then the court begins to think about it. And they say, well, if your effort is to reduce fraud, why wouldn't you just screen everyone? They say, well, because it'll take too much time. So what? Right? If you're really trying to eliminate fraud, wouldn't you want to check every single application? And really, how much time are we talking about here, right? You have a white fill out a form that's one page says, I don't work, right? My income is 0. Okay, you get your benefits, right? How much of a convenience is it actually eliminating? And then the court might ask, how much fraud is there, right? Have you actually investigated if there's fraud? Do you actually have evidence that all these people are signing for benefits when they don't deserve them? Have you done a study? Have you done an investigation? And then it turns out that, maybe the problem you're trying to eliminate is not really a problem. You don't have this instance where people are applying fraudulently for benefits. And maybe the convenience isn't really that convenient. That's a very simple process. You just check off one form. So then you say, well, if the goal you're trying to achieve isn't really the goal you're trying to achieve, and the means you're using are not very effective to root out this fraud, maybe there's some other reason that you have this position. And Catherine, you used a very important word. She said pretext. Pretext, pretext. And what's a pretext? A pretext is where you say you're taking an action for reason A. That's not the real reason. You're really doing it for reason B. Reason A looks good, right? Reason A is, we want to eliminate fraud, we want to make convenience, whatever, right? That's reason A. But reason B is something you don't want to say out loud. Reason B is the actual motivating reason. And in this case, I think reason number B, is a few of you hinted at, is a view of women as homemakers, right? That's the woman's place. And if a woman says she's a homemaker, that's what she is. But the man is the breadwinner, the king of the castle. And if a man says he's dependent, he's probably lying. How can that be that a woman's making more money than a man? So you might say that this policy is premised on a stereotype, right, of a woman's place. So if the state interest is not actually about preventing fraud or eliminating convenience, whatever, the state interest is actually women are inferior. Or at least women are probably not supposed to be the primary breadwinners. Is that a permissible state interest? Right? Does that make sense, everyone? All right. If we're proceeding in a rational basis review, does that sort of classification pass muster? Maybe, maybe not. Depends how rigorously you enforce it. But that sort of classification could potentially survive a rational basis challenge. In Frontiero, though, the court does not agree on a standard of review. The majority, I shouldn't say that. What's called the plurality. People don't know this word. Plurality. You'll see this a lot in ConLaw, especially for reading next week. Plurality. What's a plurality? A plurality is where there's no majority opinion. There's no vote that gets no position that gets 5 votes. Right? A plurality is where no position gets 5 votes. And Frontiero is an example of such a case. There's an opinion joined by 4 members of the court. Justice Brennan wrote it. He has Brennan, Douglas, White, and Marshall. And they say that sex-based classifications are suspect. And they should be reviewed with strict scrutiny. But 5 justices say we don't use strict scrutiny. So the holding of Frontiero was not very clear. It would become clear for a couple years later. But at the most basic level, sex discrimination was viewed differently than race, at least here. Now, Justice Brennan tried to get the same as race. He says that sex is immutable. Who's next? Macy here?
Yes.
What does immutable mean, this word that comes up in the Brennan opinion? Immutable.
It means like you can't hide it. It's obvious. but it's also like you didn't decide, like you just are that characteristic.
Were you? Can it be changed?
In this context, no.
This question gets hard every year, doesn't it? Yeah. All right.
Yes.
Right. So historically, thank you, Macy. Historically, the definition of immutable is it cannot be changed. To quote the Lady Gaga song, "You were born this way," right? This is who you are. That phrase has sort of gone on the not used so much anymore because now we have trans issues where it's not so clear what immutable means. But at least in the 70s, this was the phrase people used, and Brennan was trying to get it to stick to elevate sex discrimination to the same level as race discrimination. And to this day, it kind of is, but kind of isn't. We'll get to the Virginia case later. All right, but at least 4 justices willing to give strict scrutiny to sex-based classifications. It didn't work. The court agreed majority that this law was irrational, right? And I think it's significant that even a majority of the court said this flunks rational basis test, right? If the only reason you're doing this is because you presume women are homemakers, that's not a good reason, right? The state can't have a policy based on these sorts of gross stereotypes, right? There's no good reason to do this. If you're really worried about fraud, you can just ask every person to check a box saying, are you the majority earner or are you a dependent, right? And that would take 2 seconds. So when you have such an easy way to resolve these disputes, you don't need it. All right, so questions on the Frontiero case? Okay. All right, who's up next? It's called Macy. Denver, you here?
Yes.
All right, Denver, help us out and give us the facts, please, in our next case, Craig v. Boren.
Okay. So men in Oklahoma that were under the age of 21 could not buy non-intoxicating beer.
Oh, it's called light beer. It's intoxicating, but it's very low alcohol content.
Okay, got it. Okay, so
you have to drink a lot of it to get drunk, apparently.
Yeah, apparently. So males under 21 couldn't buy light beer. However, females could buy light beer at the age of 18 in the state of Oklahoma.
Good. All right. Thanks, Denver. So, by the way, has anyone ever had light beer? I don't drink at all, so I don't even know. But has anyone ever had it? Is it anyone? 3.2%. You've had it, Denver? Is it? Do you get drunk on it? I mean, what is it?
It takes a while. Takes quite a few.
Lainey? Same?
Yeah, I remember when this was a thing and Ohio was changing the drinking age. I thought they didn't even make 3.2 beer anymore. Like, why bother with it?
Apparently.
Oklahoma still has that, I'm pretty sure.
Does it? Well, I don't know. I'll take your word for it. Thank you. All right. So Oklahoma has this law that seems to give a benefit to women, right? Or I don't know. That they can buy this cheap light beer. I don't know if it's cheap. But they can buy this light beer at 18, but guys can buy it at 21. Now, again, this case was brought not by a woman who was complaining, but it was brought by a guy, Craig. And Craig argued that it was unconstitutional that he could not buy beer at the age of 18. And there was another plaintiff, one of my favorite plaintiffs, the Honk and Holler Grocery. Honk and Holler Grocery. What the heck was this? It was a drive-through grocery store where you'd pull up your car to this kind of like a drive-through, and they put groceries in your car and you drive away with it. And basically, it's a drive-through beer, right? You know, you have these. It's basically a drive-through beer store. You get beer drive-through. God, I didn't think this was a real thing until I came to Texas. Like, okay, it's a real thing. You get drive-through beer. I know in Louisiana they have drive-through daiquiri places, which makes lots of sense. But that's where we are. So you had a grocery store suing, which was always a weird fit because the grocery store was asserting the right to sue on behalf of its male customers. Does that make sense? The court held, it was the 70s, nothing mattered, Brennan. Yeah, sure, why the hell not? Yeah, that basically a grocery store can sue on behalf of their male customers. Why not? So this is actually a very important precedent about who can sue for whom. Why does an abortion clinic sue on behalf of the women who are getting the procedure? Shouldn't it be the women suing? And this is an issue to this day that divides the court. And the court sort of settles that, yeah, fine, the providers can sue as well on behalf of their patients, and the grocery store can sue on behalf of their customers. Kind of a weird fit, but that's the law we have. All right. So in Craig v. Boren, they have this policy: 18 for girls, 21 for men. All right. Those Denver. David, you here?
Yes.
All right, David. So let me ask you the same question I asked before to the poll. Why did Oklahoma enact this policy?
Well, they referenced a lot of statistics about teenage men and the propensity to cause accidents and to get more DUIs and things like that. So I assume they're probably trying to make maybe highways safer.
Okay, they want to make roads safer. Is road safety a legitimate government interest? Is government an interest in keeping highways safe?
Yes.
Okay, we'll agree on that. Okay, good. Thank you, David. So, the government says, we want to make roads safe. And the ways we're going to make roads safe is by reducing drunk driving. And the way we're going to reduce drunk driving is to make sure we have male teenagers off the road who are drinking this 3% beer. Okay, well, that makes sense, right? If you reduce the number of men drinking beer, it's more likely there'll be fewer men driving drunk. I think that that makes sense enough. Evan, you here?
Yes, sir, I'm here.
Okay, so Evan, if the state is worried about men DUI, men drunk driving, why is the state apparently not worried about women DUI, women drunk driving?
Well, like the court said here, that the sale was like an arbitrary reason.
No, I get to the arbitrary, but in the state's view, why were they more worried about men drunk driving than women drunk driving?
Well, just statistically, that men were more dangerous, I guess, on the roads than women.
Ah. So they said, we don't need to be strict for women as we do for men. Is that what you're getting at?
I think that's what they reasoned that, just due to statistics in the state, that's why they prohibited 18-year-old men from buying it.
Okay. All right. Thanks, Evan. All right. So the state here says, look, we have statistics, and the statistics show that men are more reckless drivers than women. Women are safer drivers. And we're just not as worried. So we'll give women certain privileges that we wouldn't give men. We're willing to accept the risk that women will drive drunk because it happens less. But we're not willing to accept the fact that men will drive drunk. Now, of course, what happened in Oklahoma, probably all the girls bought beer for the guys. Just come on. I mean, we all know exactly how that happened. I mean, you're all smiling. That's exactly what happened. Mr. Craig was full of it. If you want a beer, he can get it in 5 seconds. He just do it. Come on, that's just stupid, right? This is like if you lived in a border state where the drinking age is lower, you just drive there to buy beer, right? That's what you would do. So what happens, all the girls would buy beer, and then they'd be popular, and the boys would pay for it. Actually, a funny related story, there was a school in upstate New York. In the area, there was only one Chick-fil-A. And the only Chick-fil-A was in the airport, right? And all these college students really want Chick-fil-A. So what they do, they all pooled together, and they bought a one-way ticket for one guy to take. He didn't actually fly. He just went to the airport, checked in, bought like $300 at Chick-fil-A, and went back out and gave it to his friends. And he just threw away the ticket. Right? So my point is, college students know how to get stuff. They know how to get beer. They know how to get Chick-fil-A. They'll find a way. But practically speaking, at least in the law, women can get it and the guys couldn't get it. All right? Because women were safer. Now, in our first case, Frontiero, there's a question for Taylor. Are you here?
Yes, I'm here.
Thanks, Taylor. So, Taylor, in our first case in Frontiero, the government didn't really have a good rationale for why they were doing this, other than women were just homemakers, right? Stereotypes. But here they have some, numbers to back it up to show that women tend to be safer drivers. And I think, I'm not asking you to speak from experience, but in my experience, that's probably true, especially with teenagers, present company included. I'm talking about myself, right? Insurance rates tend to be lower for girls and for guys, for cars. If you have young sisters or brothers, you probably know this. So,
2 little brothers. So, yes.
Can you vouch for this, Taylor?
Yes.
Okay, well, I won't ask anything else, but I appreciate that. Thanks for volunteering. Here they have numbers, right? Why are the statistics the government gives here not enough to save this law?
Because there's such a small difference. The court says that it's not trivial, but it's hardly anything, and it's definitely not enough to base a gender line on.
So how much do you need to support a gender-based discrimination, a sex classification?
That is a very good question.
Oh, so I'm asking you. That's right.
Probably, at least more than the difference between 0.18 and 2.
Okay, well, I'll take that. All right, thanks, Taylor. So we have here numbers, right? And the government puts forward numbers to show that girls have lower car accident rates, girls have lower DUI rates, right? Less likely to be arrested for DUI. They're safer. So the court has a couple of responses. The first, the court says, well, the difference between men and women is not huge, right? There's a difference. We acknowledge it, but it's not huge. What the court seems to be saying is to the government, you need to have really good evidence to justify treating men and women differently. And a small statistical distinction is not going to cut it. But then the court seems to say, who cares about numbers, right? Because the numbers are false, right? Justice Brennan basically says, I know better. These numbers are bogus. Why? Well, in our society, it's unsurprising women are arrested less for DUI. Why? Because women will get out of tickets. I will not ask anyone to raise their hands, but it is, at least in Justice Brennan's mind, the cops are less likely to write up a girl for drunk driving than for a guy for drunk driving. He says, well, maybe for girls a DUI, they'll drive the girl home to their father and they'll let the father deal with it. They won't write her up for an arrest. But if it's a guy, they'll throw him in the slammer, right? Is that true? I don't know. I've never gotten out of a ticket. I don't know. But apparently Justice Brennan thinks that's what happens to female drivers, which I guess is another stereotype. I mean, I never thought of it that way, but he's using one stereotype of women to beat another stereotype of women, that they're getting out of tickets all the time, which I don't know if that's accurate. But ultimately, Justice Brennan says, we can't trust these statistics, and we need to say this is not permissible. All right, so any questions so far? All right. Justice Brennan was very good at what he did. He realized he did not have the votes for strict scrutiny, but he didn't want to do rational basis. So he sort of, how to describe it? He sort of made up a new standard of review. And he didn't really tell you what he was doing. He was very crafty. The way Brennan would do is he would simply say something and then just clean up a couple years later and just figure it out later. Like, he'd always do this. He would just say something and it didn't really make sense. He knew people would know what he was doing and he would clean up later. So here he put together what would ultimately become known as intermediate scrutiny. or middle tier scrutiny. They call it different things. Now it's just called intermediate scrutiny. And he gets to this test. It's in the very last paragraph of the opinion, the very end, right? The very last paragraph. And he says, I'll just paste it. It's so damn long. There. That's what he says. He says, in fact, when it is further recognized that Oklahoma statute prohibits only the selling of 3.2% beer to young males and not their drinking the beverage once acquired. In other words, the kids can't buy the beer, but they can drink it. Then he says, even after purchase by their female companions, like, look, what's going to happen is the girl's going to buy for the guys, and the guys are going to drink it anyway. So this law is stupid. Right? Oh, who just put that question in there? That's actually a good question. Doug asks, simply stopping from buying or drinking was not more than a reasonable way of attaining it. Yeah, think about it this way. They only banned the buying and not the drinking. Could they have banned the drinking as well? And this gets to an important point, right? How precise must the government's actions be? Must the government act with precision to enact a perfect statute? Or can the government act incrementally and do a little bit at a time? Justice Brennan, he's saying, they got to do a really good job to justify this law. Usually this is sort of routine that strict scrutiny requires, but not for a rational basis. Okay? Let me finish reading my sentence. So, even after they're purchased by their female companions, now here comes a test. It says, the relationship between gender and traffic safety becomes far too tenuous, far too weak to satisfy the requirement that gender-based differences be substantially related to the achievement of the statutory objective. That's the magic word, substantially related, right? It's measuring the fit between the means and the ends. I think this was Catherine's point a few moments ago. Okay? It's measuring the fit between the means and the ends. If your end is highway safety, what you're doing won't actually make the highway safer, right? It might reduce some boys from buying beer, but they still can drink it. And their girlfriends will buy it for them, and then they can have beer. So if they're really interested in highway safety, what are they going to do? Ban beer for everyone. If they're really interested in highway safety, they would also make it a crime to drink the beer. But they didn't. And the fact they didn't take these apparently logical steps shows that highway safety was not their primary motivation. Just as Brennan says. Their primary motivation, Brennan says, was to reinforce stereotypes that women being these delicate, fragile beings who can do no wrong, and boys, these rambunctious troublemakers who are going to go drag racing down the streets of Norman, right, and making a mess. Or something like that, I don't know. So in the end, the court says that the Oklahoma law was unconstitutional, even though they had statistical evidence showing that women were safer drivers. Okay. And here, Brennan got 5 votes. You got a majority. All right. Questions on the majority in Craig? Yes, Eleni, go ahead.
Does equal protection mean equal enforcement? Like, who are we protecting? I guess we're protecting the teenage boys from themselves. And it's an equal protection for the teenage women. We're trusting them. We're not protecting them.
So the text of the Constitution, right? The text of the Constitution says equal protection of the law. The word protection has no basis in modern jurisprudence, right? They're not protecting anything. The courts construe the phrase equal protection to mean equal application. Right? That the law applies to everyone equally. Josh, and Randy and some other people think this is a mistake. And almost the entirety of modern equal protection jurisprudence is wrong, right? It's not based on applying the law equally, it's about protecting people. How did the framers of the 14th Amendment think of protection? For example, if the Ku Klux Klan was lynching people, the state had a duty to protect you from the Klan. That is a better reading of equal protection than what we have today. Most laws we think of as imposing arbitrary classifications were actually due process cases. That's why Yik Wo, which we studied, was really a due process case primarily. Equal protection as well, about protecting rights, but it was primarily a due process case. That a law imposed for an arbitrary reason is a violation of due process. So this is my own view. Don't learn this one, ignore what I just said. Just rip out your notes. But Laney's question, I think, is good in that it asks about the text of the Constitution, and the text has nothing to do with what we have today. It's just sort of where we are. The word equals in it is good enough for the Warren Court. Yes, Miha, go ahead.
So this case, in Brennan's opinion, is what started to craft the tiers of scrutiny test?
Well, the tiers of scrutiny existed for decades. This case clarified there was a middle tier.
It clarified the middle tier.
Well, depends who you ask. Some people said it was always there. Brennan will say it clarified. I'd say it inserted it.
Okay, thank you.
Now, around this point of the semester, people are like, oh, God, thank you. There's 1, 2, 3. It's not so clear. There are other cases that say they're applying rational basis, but actually apply something higher. It's not clear where sexual orientation fits in this matrix. It's not clear where other bases fit. So we have this sort of elaborate 3-tier framework that was very popular in the 70s. And throughout the 90s and early 2000s, the court abandoned it because Justice Kennedy doesn't like scrutiny. Right? Justice Kennedy does not like scrutiny. He never uses it. So all this work which you're doing to figure out these 3 tiers won't matter next class. It won't matter. The court just abandons it because Justice Kennedy doesn't care. But enjoy it now while you can. Questions to the majority and Craig? All right. We have some concurrences and dissents. Justice Powell concurred. And he says, I won't go along with strict scrutiny, right? But I'll go along with this sort of middle tier approach. He calls it middle tier, which is a name that did not stick. But that's what he called it, middle tier. Justice Stevens had this sort of unique view that there was no tiers of scrutiny, that there was just one equal protection clause, which has a benefit to it. But he doesn't really say how he would review different classifications. So that's Justice Stevens. Justice Rehnquist was the most conservative member of the court at this point. He was kind of annoyed. He said, this is wrong. First off, why are men challenging sex discrimination statutes? This should be women, right? Why are men complaining that they're getting some benefit to women? This reminds me of Justice Holmes' opinion. The draft opinion he wrote in Buchanan is like, why is a white person challenging a segregation ordinance, right? It's not his problem. He can go live wherever he wants, right? Rehnquist says, why is a guy challenging this? For once, the law treats women more favorably, and now a guy's challenging. This makes no sense. Rehnquist also objects to creating this new tier and elevating sex discrimination. Rehnquist would stick with rational basis review. And he cites Williamson v. Lee Optical. This was a famous case that repudiated Lochnerism and then sort of adopted the Holmes dissent from Lochner. But Rehnquist is not happy with this test. Excuse me. All right. Question about the Rehnquist dissent. No? All right. So let me summarize. I told you that I had to shorten your syllabus this semester because I just didn't have enough time. Usually at this point, I would assign some cases from the 80s and from the early 90s, which I don't have time to assign anymore. But I'll just tell you that what they're called. One case is called Cleburne, Cleburne, Cleburne versus Cleburne Living Center in 1985. I'll put the name in the chat so you can tell us out for your notes. Again, I don't have time to assign it, but this case involved a classification against mentally handicapped people, or as I said, mentally retarded was a phrase they used back in the day. And you basically had a city in Texas, always Texas, that denied a permit to a group home for certain handicapped people. The group home challenged the ordinance, and the court declared it unconstitutional. Now, the court did not say that discriminating against handicapped people was a suspect classification, and they did not employ strict scrutiny. They said they were applying rational basis review. But how can you win with rational basis review? This was a case where the court seemed to do something more. They applied what might be called rational basis with bite, or rational basis with heightened rational basis review, right? Where they sort of were much more rigorous in their reviewing process. So, you have strict, you have intermediate, you have rational basis, and you have this sort of like in between, this rational basis plus between intermediate. So you have, instead of having 3 tiers, you have 4 tiers. There's another case decided in the 90s called Romer against Evans, which involved gay rights. And Colorado enacted this amendment that said, you can't give special protection to gay people. I'm summarizing grossly. In Romer against Evans, the court also purported to apply rational basis review, but they found this law was unconstitutional. The court did not say that sexual orientation was a suspect classification. They said nothing about it. Romer was a Kennedy opinion. He doesn't like scrutiny. So now you have these 2 major opinions, Cleburne and Romer, where the court says they're applying rational basis review, but it looks a lot like something higher, and they don't really acknowledge it. We'll do more cases next week with gay rights, which makes this case even more complicated. But the simple answer is the court doesn't really do scrutiny anymore. It was very important for the 60s and 70s, and after that, it stopped mattering. Macy asked, haven't we seen another heightened rational basis review? I can't remember the case. I don't think so. Does anyone know what you're thinking of? I can't think of it. Not sure. I don't know. Not sure. All right. Questions so far? Again, if you want to read about Cleburne and Romer, just pull up the 100 Cases book. We have a chapter on it. It's very short. It'll be good for your knowledge, but I don't have time to teach a case this semester, unfortunately. Well, if it's race discrimination, it's strict scrutiny straight up. You don't have heightened. When I say heightened, I mean it's not strict scrutiny, but something more than rational basis. Oh, you're asking about the commerce cases. Yeah, I mean, that's using scrutiny in a very different way, though. That's sort of a separation of powers case or a federalism case. I'm talking about equal protection scrutiny. All right. Any other questions on... Excuse me. Any other questions on... intermediate heightened scrutiny? All right, let's do our last case then. United States against Virginia. Of all of Justice Ginsburg's opinion, this is probably the most popular one, or at least the most well-known opinion. In the various eulogies, people always cite this one case. And frankly, it's because she didn't have that many other big cases. She had a lot of really good CivPro cases. She was excellent at CivPro. But most ConLaw cases, she was not in the majority. She was in dissent. She had some excellent dissents, but this was probably the most significant majority opinion. Who's next? Alexandra, you here?
Yes, I'm here.
Okay, thanks, Alexandra. Do you want to please give me the facts in U.S. versus Virginia?
Yes, this was where the Virginia Military Institute, it was a public college in Virginia, and they weren't allowing women to enroll in their college. So they, the United States filed a lawsuit on behalf of the women for them, and they went to the Court of Appeals and everything, and the Court of Appeals was said that this isn't good, but they could fix it by getting another college for the women, which they did. And then they later went to the Supreme Court, where it was determined that it was not constitutional because they made a separate facility for the women, it was not equal to the College of the Men.
Okay, very good. Thank you, Alexandra. All right, so VMI was an old military academy in Virginia. It had been around since before the Civil War. For over 150 years, it had been only men were allowed. Okay? Now, Alexandra, Vanessa, you here?
Yeah, I'm here.
Vanessa, let me ask you a question, please. Same question I posed to everyone. Why did VMI, the Virginia school, impose this sex-based classification?
I think it's because of the way that they carried out their education. It was through an adversative model of education that had physical rigor, mental stress, and absolute equality of treatment, the absence of privacy, and etc.
Okay, so they want to do this in this aversive method. Why could they not do this with women on campus?
Maybe it would affect the system that they had in place. I mean, they talk about a lack of privacy, for example. Maybe they feel like if they had women there, it might change the circumstances.
Why? Who cares? Why can't you have it with women? You sort of... Why? I'm asking a hard question, I know, but so what? Why can't you have women in this method?
Maybe I know at some point they say that the parties agreed that some women meet the physical standards required.
But I'm sorry, we'll get to the physical standards, but you mentioned privacy. So what? Why? Who cares if you don't have privacy? I'm asking this question very deliberately.
Yeah.
Why is privacy so important? Who cares if they have to shower next to each other? I'm being specifically provocative, I know. But I mean, why does it... What's the risk of having changing areas, showering, bathrooms, co-ed?
Some sort of sexual harassment, maybe.
Sexual abuse, maybe?
Mm-hmm.
Which way would that go? More likely than not.
Which way would that go?
Who'd be harassing whom?
Oh, the men would more than likely be harassing.
Yeah, thank you. That's what I was getting. Thanks, Vanessa. I think that's right. So let's just be a little candid here, right? Would it be possible to have men and women in the same showering, in the same, bathrooms? Sure. And indeed, if you read in certain sections today, if you go to certain restaurants, bathrooms are co-ed, right? That's increasingly, you see this in different places. You have different stalls, one next to each other. But the school was afraid that if they had men and women together, there would be a risk of having them in the same bathrooms. Now, Justice Ginsburg, actually acknowledges, among other things, that you can have separate bathrooms. She actually says that it's possible. She has a footnote about that. Unclear how that would come out today. Now that she's gone, we don't know, but unclear how that would come out today. Now, that's part of the reason why. Another part is, I think Vanessa mentioned also, the training. Is the training different? That is, what if women couldn't physically perform through this aversive method. And this raises the question of, are there physical differences between the sexes? We like to say with the case like Brown and otherwise that with respect to race, there's no difference. Black and white students can learn just the same in any classroom. But can you say the same thing for physical fitness tests? For example, this comes up a lot with firefighters, right? To become a firefighter, you have to pass certain very rigorous physical fitness tests. You have to carry this huge dummy up a flight of stairs. These different tests. Should the standards be the same? Right? If you have a person doing a rescue in a building, do you want a lesser standard of how much weight they can carry if they have to carry down a flight of stairs? Right? Or, how many minutes run a mile? Right? Do you have a reduced time? Justice Ginsburg also says there might be certain physical differences. Now, why does this matter? I think the Virginia case at least suggests that there's some difference between race and gender. That maybe the reason why you have strict scrutiny for race is because there are no good reasons to treat people differently in their skin color. But I think what Ginsburg is getting at is there might be some reasons why you treat people differently based on their sex. But, and here comes a big but, you need a really good reason to do it. You can't just have any reason. And if there's some way to accommodate women, then they have to choose these other means. They can't simply exclude them altogether. Everyone with me? All right, so that was Samuel here?
Yes, sir.
All right, Samuel, so help me out here. What's the test? What's the test that the majority puts forward to know when a sex-based classification is unconstitutional?
It seems like Ginsburg is going with the intermediate test, but at the same time she adds an extra bite to it, as you were saying earlier about it. The government interest would need to be exceedingly persuasive.
All right, so she uses intermediate scrutiny, but she says that what exactly is to be exceedingly persuasive? Just tell us again.
It would be the government would have to prove that their interest is exceedingly persuasive to impose that classification based on sex.
All right, so let me ask you a follow-up, Samuel. How is a court to decide whether a government's interest is persuasive enough? What does that mean?
If they have an important enough objective.
Right. I know, but you substitute important for persuasive. How does a court know what important means or what persuasive means? How is the court supposed to know what persuasive means or important means?
Exactly sure on that one, sir.
Right. I mean, if I ask you, Samuel, just in your own mind, right? Is having an all-male military academy important, right? If I just ask you, how would you go about deciding if that's an important enough interest? What would you look to? What sources would you consider?
What's the purpose of having the all-male school in the first place?
Okay, so we have this aversive method, this very confrontational method. Is that important enough?
If you're looking at what it's trying to achieve of the citizens, soldiers, I think the court looks into it about whether you can modify it.
No, I get that, but I'm asking, forget the court for a minute. Sure. How is a judge to know what's important? What do they have to look to? What sources? What authority? You're struggling.
A little bit, just because it looks like the past for the school, I guess, kind of what the outcome has been.
Like tradition, you mean?
Well, they kind of pointed to, with the leaders that they have of what has come out of the system, kind of like proof in the pudding is
like Robert E. Lee. Sorry, that was bad. There's actually a huge controversy now because there's a huge Robert Lee statue on campus, and they're debating whether to take it down. So that's why I just brought that in. But yeah, I mean, they have a lot of very famous alums. Actually, did Robert Lee go there? I know they have a statue of him, so that was perhaps mean. I think actually Robert Lee went to West Point, so I'll take that back. Right. Hold on. Okay, so thanks, Stuart. Enough difficulty for you. No, Stuart's next. Yeah, Stuart, what do you think? How does the court supposed to know what's important?
I guess trying to find the goals of the school, what they're looking for. But, I mean, average state of that doesn't immediately tell me that can't be co-ed. I don't know. I feel like law school's training us to be average state as well. Genders, you know?
We said law school is adversative? Oh, God. Give me a break.
I mean, it teaches us to be like an adversarial system, you know?
All right, fine. Adversarial, perhaps, not adversative. My God,
I don't know what that word is. I'm just guessing it's adversarial.
No. It's very different. I think the court describes it. They put you through this thing where they try to destroy you as a person, physical fitness and enduring thing. It's very hard. All right, fine, okay. And yes, and he was right. Lee did go to West Point, so I apologize. There is a Robert E. Lee statue at VMI that they're debating taking out, so I misspoke. I apologize. Stonewall Jackson taught there. That was it. I got the wrong general. I'm sorry. Mea culpa. But yeah, I think Stuart raises a fair point, right? How are we supposed to know what's important? How are we supposed to know what's important? Judges have to look within, right? For a judge to know if an interest is compelling or important or substantial or persuasive, whatever label you want to use, you have to look within. So you have Justice Ginsburg in the majority. She said, this is not persuasive enough. The school doesn't really need this. Right? They don't need this. They can get by with women in their class. And in hindsight, things actually worked out, right? It wasn't the end of the world. They were able to adapt. But then you have Justice Scalia, who was pissed here, right? Scalia was not happy. He was by himself also, right? Justice Thomas's son recused. I'm sorry. I combined two thoughts. Justice Thomas's son went to VMI, so Thomas recused. So Scalia was all by himself. And he was not happy. This is actually one of his more bitter dissents of all time. He's really angry here. And Scalia says, who are we to decide this question for Virginia? If Virginia decides that they think this is useful for them, then they should be able to keep it. Right? How are we supposed to know this is not persuasive enough? Right? We've never been in the military. Actually, Scalia went to a military high school. He went to Zavarian High School in New York. So he actually had a military high school. Not quite this bad. In my office, if you ever go, I have a copy of all their yearbooks. I have Scalia's high school yearbook. I have Ginsburg's high school yearbook. I have Rehnquist's high school yearbook. And a couple others I have in my office somewhere. So if you ever go to my office, I'd be happy to show them to you. But, Scalia's like, this is not for us to decide. Scalia's also pretty pissed off about the expansion of intermediate scrutiny. We're going to have these three tiers, and what Scalia says is this decision sort of expands the middle tier such that there's not much of a distinction between strict scrutiny and intermediate scrutiny. And I'll tell you that's pretty much the case. To this day, generally sex-based classifications are not going to win. It's going to be a very rare sex-based classification that's upheld. Very rare. Indeed, it's not clear to me, even if intermediate scrutiny has any distinction between strict scrutiny that actually matters. So what this case basically said was, we're going to treat race and sex just about the same. And maybe that's what you like. That's the answer. In which case, let's stop calling it two different things. Just say we're just going to say race and sex discrimination is no good. Right? Put them in the same category. Okay. Scalia words would open the floodgates of litigation. hasn't actually done that. You still have some same-sex education. You have same-sex schools, but not public institutions. Okay. All right, questions on VMI. It's often called VMI or the VMI case because of Virginia Military Institute. But call Virginia if you wish. Any questions? All right, let me try to summarize a bit if I can and perhaps bridge you to the next class. Next class, we're going to be beginning our discussion of modern substantive due process with the abortion cases. We'll do Roe, we'll do Griswold. And then the next class after that, we're going to do the modern, more recent abortion cases, Casey, Whole Women's Health, and the brand new, never before taught, for me at least, June Medical, which was just decided 4 months ago. So always an evolving class here. I have to always take stuff off and add new stuff. But we're now done with our topic on equal protection. With equal protection, keep in mind what year are you in, because at different junctures, the court had not recognized these different tiers. So on any exam question, be very careful that you know what year you're in. Right? If you're in the 1800s or the 1900s or 1950s, you're going to have to apply different tests. But where things stand now is we have these three general tiers. If you have a racial classification, you have a suspect classification, it's strict scrutiny. If you have sex, you have an intermediate classification, or quasi-suspect classification, intermediate scrutiny, and everything else is rational basis review. People ask, other than race, what else is strict? Nationality. That's about it. That really matters for you. People ask, Josh, what else is intermediate scrutiny? A characterization that doesn't matter anymore is illegitimacy. Huh? If your parents are unmarried, can the government deny you certain benefits? And believe it or not, there are cases that says illegitimacy is basically the same as sex. It makes no sense. I don't know. It was the 70s. Nothing mattered back then, right? So really, it's just sex. Yes, Josh. What about sexual orientation? To be precise, it's a rational basis standard, but the court applies a very rigid review of LGBT. It wasn't even T, but just sexual orientation classifications. You'll find this entire area of the law is an absolute mess. Thank you, Justice Kennedy, because he doesn't care about scrutiny. It just doesn't matter to him. Okay, that is equal protection that is a scrutiny system for equal protection. We're going to do due process tomorrow, and what confuses people is you also use the phrase scrutiny for due process. We have certain fundamental rights that are given strict scrutiny. You have certain non-fundamental rights that are afforded rational basis review. Abortion cases have even a third standard called the undue burden test, that laws restricting abortion cannot impose an undue burden. Right? So you have these phrases, rational basis and strict scrutiny, applying in both equal protection and due process. Now, someone earlier said, didn't we see the phrase rational basis in the Commerce Clause cases? Yeah, you did. In some of the Commerce Clause cases at the start of the semester, you use the phrase rational basis. Torturing you, right? Next semester, you might take First Amendment. Maybe you'll take me. I'm teaching it. If you can handle another semester of Zoom, right? In the First Amendment context, you use the phrases strict scrutiny and rational basis as well. Certain free speech laws are viewed with strict, intermediate, or rational basis. In the context of free exercise of religion, certain cases are reviewed with strict and rational basis. Right? The Second Amendment, there's discussions of rational basis and intermediate scrutiny, right? You'll see throughout the entire body of ConLaw these phrases strict, scrutiny, and rational basis just recurring in completely different contexts. And in each context, these phrases have different meanings. Lainey, I see your hand was up.
Yeah, I was just typing you a note. If we were taking First Amendment with you, is it the same casebook?
It is.
Awesome, thanks.
Same casebook and same supplement, so you don't have to buy anything new. Basically, the last 4 or 5 chapters of the book we'll be covering. Oh, I'm sorry, I should have said that. Yeah, same book. You don't have to buy a new one. And if you didn't have me for ConLaw, I guess it wouldn't apply to any of you, but we actually sell a shortened version of our casebook that's basically the second half of the book, just the rights case. So if anyone didn't have me, they can buy it. It's half the price. All right. I think I'm done. Questions? Yes, Ashley, go ahead.
I just wanted to make sure the way to trigger the equal protection cases, no matter what you're in, is the classification.
Correct.
Not the burden. That's due process.
Correct. With equal protection, you ask, how is the government separating people or treating people differently? With due process, we'll talk about next week, or next class, I should say, it's we ask, how is the government burdening a specific right? But look, they're often very closely linked. So, for example, a ban on gay marriage, right? Is that classifying people based on their sexual orientation? Or is it denying a right to a marriage license? Or both? So this is why Justice Kennedy doesn't really care. It just all mixes together in this sort of this goulash of ConLaw. Thank you. Good question. Right. Is a law restricting abortion a classification against women because only women can give birth? Or is it a restriction on the right to abortion? Right. It's the same issue. You can view from different perspectives. Almost, if you get creative, almost any due process case can be an equal protection case and vice versa. So the line between them is very blurry. All right, anything else? All right, we are at time. I will start the minute poll now, and I'll be back here in about 20 minutes for office hours. Thank you all so much.